Miriam, you can hear me?
Yes, I can.
Yeah, we had a problem. It crashed, but we continue nevertheless. So I told you here, miscellaneous criminal application usually put here. Then applicant, respondent to the person you are supposed to charge. You are seeking leave and the DPP are the second respondent. Sawa.
Yes, Mwalimu.
Then at the article 156 on DPP, it does not talk about private prosecution. So you omit, the only relevant section here is section 28 of ODPP Act, because it talks about private prosecution. Go to that one in an exam. That is enough. Take notice that seasonable court to be moved on the following day of 2016 and on the forenoon soon thereafter may appear to the daily course list so as the counsel for the applicant or the application for orders. That the honorable court to be pleased to grant leave to the applicant to commence prosecution, private prosecution proceeding against bullfighter, the respondent, for the offenses of assault causing bodily harm contrary to section 251 of the Penal Code. In the criminal application, no need to pay for cost.
Mwalimu, I can't hear you.
You can't hear me? Now you can hear me. You can hear me? Hello?
I'm having a hard time hearing you.
And the way I can hear you clearly, loud and clear.
Oh, now you're back. Now you're back.
Okay. I'm saying no need of, you can see the screen. Hello? You can see the screen.
Yes, I can.
So
Yes, I can.
no need of applying for cost in criminal application. Cost is most likely is in civil litigation application. Sawa.
Yes, sir.
So which application you made on the following grounds? We said here the grounds that you put in the pleading should be legal grounds. The respondent and also assaulted the applicant. The applicant reported the issue to Lakeview Police Station on that the police are aware of the said against applicant and failed to institute proceedings against the respondent. So here you can put C is enough. You can say that the police investigate on the grounds that the police investigated the respondent and the second respondent failed in their mandate under the Constitution Article 156 to institute criminal proceedings against the respondent. These are the factual issues. You can put them in an affidavit. Sawa?
Yes.
So I dated this. I someone resident on Nairobi County 20 Republic that a male adult of sound mind applicant that on April 15, that reported here. You gave the story. You gave the story, which is good. Then in a question where you have been able, there have been documents given. You can the purpose of an affidavit is to to attach the document or produce them. So you can say, for example, I reported the case. Attached is the report slip as attached as Annex 1. Then annexed is after giving the story is the letter dated annexed. Then annexed is the photos. You annex the documents here. Are we together?
Yes, we are.
Yeah, so the documents, if documents have been given in the question, civil or criminal, you mention them in the supporting affidavit. So, but generally you did the private prosecution well. As I've said, this question was last tested in 2016, drafting, and the theory question was last tested in November 2015. So it was tested a long time ago. So these are highly likely question to come in the exams, November 2023. So we go to the next question. The next question is question 1, November 2014. Which the paper is projecting on the screen. I'm now going to read the question. Then we are going to deal with it. On 24th October 2014, at about 8 p.m., Ms. Erin Ajor, Officer Commanding Police Station Kamukoji, was conducting a special police swoop within her area of jurisdiction in Isri district of Nairobi, within Nairobi County, in her company of Coprotina Awor and Kopirowibofos Kiman. Ms. Ajor is known to be very tough, no-nonsense officer. In particular, even in the swoop that was underway was triggered by a terror alert issued by Federal Republic of Somalia. Indeed, the Federal Republic of Somalia had issued a travel advisory to its citizens visiting Kenya or intending to visit Kenya. The advisory was to the effect that there was an imminent terror threat in Kenya against Somali interest, large Horn of Africa interest, especially citizens of Federal Republic of Somalia, were warned against visiting its 3 districts and avoid large gathering. In addition, the advisory warned Somali citizens to restrict their visit to Kenya on PR essential travel. Intelligence shared between the two countries indicated that a terror planning plot was at the advanced stage in the Isri, and the execution of the plot was nigh. Of keen interest to Miss Irene Ajora and her team was a bar and a lodging on 12th Street within Isri, a district called Pin Cube. It was believed that the plot was being conceived in one of the rooms in Pin Cube bar and lodging. Miss Irene Ajon, a team was backed over by 300 regular and 90 terror police. The first point of call for the team was reception of Pinback bar and lodging. The second reception of the bar, Ms. Dorit Nambolibo, quickly availed a comprehensive list of guests. One particular name was the list aroused by Ms. Ajire's curiosity. A booking under the name Professor Ms. Tito, her daughter and partner. The two have been booked in room 320. A closer examination of the copies of the passport left at bar reception revealed that the two were South African national, but their passports appear to have been issued in Angola. In addition, they have been allowed to Kenya for 1 month, but had sought for a migration department and were granted numerous extensions of their stay, then aggregating to 6 months. The purpose of stay was described as consultant, in quote, expected in Rapside Creek procedure. No further detail was available. Ms. Ajoje decided to visit the said room. On knocking on the door, a woman opened the door and introduced him as Professor Miss Hadoto. A man initially smoking cigarettes while watching news on TV. It serves herself as Kudakwile Hadato. The man before Mr. looked very familiar to her. She could not immediately recall the point of interaction. However, Corporal Awodo recognized the man as one Joseph Kony, a rebel commander of band of that terrorizing civilians in northern Uganda under the road of Lord Resistant Army. The two were immediately taken to custody and kept at an undisclosed location pending further direction. As soon as the Director of Public Prosecution received the information of the two being in custody, the local Interpol office notified him that there had been a long-standing and unexecuted warrant of arrest issued by International Criminal Court sitting at The Hague. In Netherlands against Mr. Coney for crimes against humanity, rape committed against civilians. As for Professor Ms. Hadato, her real name is Mrs. Nanirimu Tumusime. Ms. Tumusime is a Uganda citizen wanted by Zambian authority for vessels that included harboring fugitive Joseph Kony and their relief food in Zambia Copper Belt province. The Director of Public Prosecution is hard pressed with time and requires a well-thought-out legal opinion on how to deal with the two individuals in custody. The file of the two is passed over to you. You note from the file that the Zambia is a designated Commonwealth country pursuant to legal notice number that and legal notice number that. The Director of Public Prosecution requires you the following. Give him a concise legal opinion with the aid of case law on procedure of surrendering Joseph Kony and Tusumire Namirimu to their respective authorities. Assuming that Ms. Tusumire was being made, request was being made by Kenya to Zambia, prepare the necessary documentation to facilitate the request. The question was 15 marks. This is a question what is testing three things: extradition of person to ICC, extradition of a person in Kenya to a Commonwealth country, extradition of a person from a Commonwealth country to Kenya. It is a very unique case question. It was only tested in 2014. It has never been tested again. Having the combination of all those facets of the question. And I believe having been tested in 2014, it can come again in 2023 after 9 years. So now we look at your draft that you did. The question was 15 marks. Of course, in normal circumstances, this question should be given 20 marks when you are, because drafting an extradition application is a very long document. So this question needs, the combination of all these facets of the question needed 20 marks. 20 marks, which you take around 50 minutes. So you took 51 minutes, which I don't agree with the allocation of marks by CLE on this question. So the legal opinion, you do it as a letter. You have said that also in your legal writing and drafting class. So you are giving a legal opinion to the DPP, and you can be able to, you can be told to do a memo. You can be able to do an internal memo if you are working for DPP as a prosecution counsel. So you need to know also how to do a memo. Sawa.
Yes, yes.
Yes, you can be able also to be told to draft a memo, legal opinion, because legal opinion you usually do to clients. When you're acting as a prosecution counsel and you're indeed be most likely they are going to do tell you to do an internal memo. So, or also working for the AG. So, legal opinion on procedure to surrender of Ms. Joseph Kony and to Ms. Irene Nairim. The above matters. Following your instruction, we render our opinion as follows. I render my opinion as follows because you are alone. Brief facts. Brief facts. We said you don't say a lot of things because the question, these have already been captured in the question. I realize one of the drafting you have done very well is this on extradition. And I want to use this drafting that you have done as part of the document for the website. I'm going to upload it in the notes area. So the minor amendment we are going to do, you can effect them. Then you are going to send me only this question. Sawa?
Sorry, Mwalimu, please come again. What would you like me to do?
I'm saying, this is one of the questions you did very well, from my review. So for my review, you did this question very well, and usually is a question that gives student difficulty. So from the minor amendments we are going to suggest on this question, you are going to do them like cancel. Here you can cancel. I render my opinion. You can see in your screen.
Yes, I can.
So after this you do them, then just canceling here and there. Then you scan this document alone. This question alone ikiwa peke yake. Then you send me. Then I'm going to upload it in the notes area as one of the documents there under criminal, and I'm going to refer it there down in part B, and I'm going to cite you. I can, if you like, I can cite your name. If you, the way you like. If you don't like me to cite the name yours, because this is your document, I can leave it. Whichever way you like. I can cite your name or I leave it. I just say is a student who did this drafting. Sawa?
No problem, Mwalimu.
So, brief facts. On 24th October 24, at about 8 p.m., Ms. Irene Anyonga, the SPD of the, conducting a special security swoop, arrested Ms. Joffrey Kony for the warrant of arrest. Brief facts had no problem issues. These are the legal issues. Whether Joseph Kony is eligible for surrender, and if so, what is the procedure for his surrender to the ICC? What is the procedure of surrender of Mrs. to Misire to Zambia authorities? Good. These were the legal issues. Here you put rule, stroke law. Rule, stroke law. Sawa?
Yes, Mwalimu.
International Criminal Acts, International Crimes Act, Extradition Commonwealth Countries Act. Analysis, whether Kony is eligible for surrender and procedure for the search arranger. Joseph Kony must be brought before the High Court. This we have dealt with it before. If he's eligible for the court must satisfy itself that a warrant or is issued against the accused, and if it's satisfied, the High Court will issue a warrant of detention pending the surrender. If not satisfied, the accused is discharged. After detention, the High Court will surrender a minister's report on the status of surrender and its finding. The court must inform the accused person that they cannot be surrendered at the expiry of 18 days, which he may lodge an appeal and apply for weights of habeas corpus. The minister is considered issued an order of surrender. If they have not been surrendered or removed within 2 months of issuance of surrender, they may apply for discharge. The minister will determine whether to issue an order may refuse to give reason to the High Court, issue order of surrender unless the restriction or postponement of the temporary order in place. So that was correct. What is the procedure of surrendering is to submit to Zambian authorities. A request for extradition must be initiated by Zambian authorities to the Attorney General. The request includes particulars of fugitive, the law on which the offense is based, and acknowledgement of the facts. Is further supported by overseas warrant or certificate of conviction, charge sheet, and authenticating documents. A magistrate court can then issues a warrant. For example, this is what happened in Geshoro's case. The Caribbean, that country, what is it called? This country that was required Chris Okemo and Bananas Okemo and Chris Geshoro.
Cyprus.
So this is what they did. The director of public prosecution issues an authority to proceed, which authority then the court weigh the evidence and certify offense that the offense is extraditable. The offense would warrant a trial and custodial sentence in Kenya. Fugitives is at large after conviction. If the court is certified, the court may commit the accused to custody to await surrender or discharge him if not certified. Once convicted, the court will inform the fugitive of his or her right to apply for weight of habeas corpus, and they will not be surrendered until expiry of 15 days or until determination of weight of habeas corpus. The court may also discharge or release the accused if the offense is a political nature. The request is based on their race, religion, nationality, or political opinion. And there is a question on this, on the Q&A. I'm going to just state it somewhere. Would result in discharge in Kenya. Conclusion, both Joseph Kony and Tumisinda seem eligible surrender to the requesting authority. As such, the procedure for their surrender to discuss above in accordance in the International Criminal Act and Extradition Commonwealth Act. So this was a very good drafting. Only change here what I've told you, because it was you, I render the opinion because it's you. Then here you add rule stroke law. Then we go to the next question, which was if the extradition now to Misire was a Kenyan citizen, then the request was being done by Kenya. Of course, he has run. He was hiding in Zambia. What was the request? You draft the documents, which are done by the Attorney General this question was asked in question 1A, 2 November 2014. It was asked as a direct question. No, question 1B, November 2014, was asked this as a zero question. You can also look at question A, 2 November 2014. Question 6, October 2022, also it says extradition. So, Attorney General to the Minister in Zambia, request for assistance of extradition of Mr. Misiri. I present my complaint to the competent authorities of the Republic of Zambia, and I have the honor to request for assistance in extraditing me to Misiri and obtaining evidence for the purpose of criminal investigation currently underway. The request is based made on number of bilateral agreements signed by Kenya and Zambia. Authority initiating request. The Office of Director of Project is seeking assistance on touching a criminal matter pending before court in Kenya, and which evidence indicates the subject is currently domiciled in the Republic of Zambia. Mr. Tumisire is required to answer to charges of harboring a fugitive and theft of relief food. Need for assistance. The request for assistance is made in interest of justice and will not be used for political, military, or official purposes in Kenya. Based on knowledge of the case, Mr. Misira is a Uganda citizen wanted by Kenya for violence fugitive Joseph Kene and the theft of relief food. Nature of the offense. Mr. Misira Naisimu committed theft contrary to section 275 of the Penal Code for harboring a fugitive contrary to and harboring a fugitive contrary to. Here you look at the section that is there. You complete.
I did not find one. I wanted to ask you. I don't know what the section for harboring
a fugitive. I'm going to tell you after class. You add here, before you send me the documents. Documents in support of the request, charge sheet, warrant of arrest, or the detective certificate is processed between Kenya and Uganda. The Attorney General of the Republic of Kenya, we are grateful for any assistance that a competent authority of Zambia can offer in response to the request. The Attorney General of Kenya will assist in investigation of persons within the jurisdiction of Kenya in spirit of mutual legal assistance in suppression of the crime. Undertaking, we hereby undertake to abide to the terms and condition of registration of the Republic of Kenya. This is because this request is made by the Attorney General. Here is the, you sign as the, is Nini. You sign here, is the Attorney General who signed, not the High Commissioner. Sawa. So I'm going to give you the here, harboring a fugitive contrary to today we are having problems. I think it is internet issues. You can hear me?
Yes, very well.
It's internet issues. Zoom is bringing problem, but we are going to Nini. I'm going to give you the section here after class. Then after those, you add and after those amendments, you are going to send me this question because I think you did very well. Extradition question gives student a lot of problems, and it will come. This one has not been tested, so it's worth to put there in the website. You can put your name if you like. And I'm going to say that it was done by the student. So, related to this question, you can be asked. Extradition of, they have asked only extradition involving Commonwealth countries. You can be also be asked about between non-Commonwealth countries. So use the other act, which I think the procedure is just the same, but a slight difference.
Yes.
So in your homework, go and look at on a Commonwealth country, it has never been tested, so it can come also. So go and fine tune on that. Related to this, question 1, 2 November 2014, question 6 October 2022, question 1B November 2021, question 1B November 2014. They talk about extradition, but extradition is generally a difficult area, which students usually fail. So if you have been able to do this, I'm very happy for you. So you can you are going to this document. I'm going to, of course, I did not read the others. I have not finished even finishing reading. Also, all this is part of the document. Chief Magistrate Court, Republic to Missouri, pursuant to the authority, you can be able to be told to draft the application. Then the city, the ticketing certificate. Yeah. So I think this you did well. And I think I'm going to use this document in my, I'm going to upload it in my website. Here, the taking certificate, you can send me a more clear screen and in scan. So I want us to go to the next question because of time. Let me first of all change the let me put my phone so that it does not disconnect again. Initially, I had put the phone, my phone hotspotting. This one, home Wi-Fi usually fluctuates. But now it's saying your internet is unstable. Let's see. So we are going to go to the next question. You can hear me?
Yes, I can.
So you drafted this question. You are going to look at it. This is question 1, July 2019. Of course, Yeah, I was interested with, of course, this one was a mistake, but because it's still in the topics of drafting, we are going to look at it. And we continue. Only the drafting question. So I'm going to read the question. Marimingo was charged with the offense of incest before Rumbari Chief Magistrate Court. He was accused of defying his 9-year-old niece, JMM. During the trial, his sister Anna JM mother was first to testify. Thereafter, the court took JM evidence. It transpired that JM suffered from a mental disorder which impaired his speech. The trial court nevertheless took her evidence through the mother, Anna, who appeared to have a way to communicate with her. JM testified as he was alone at home and the crime was committed. She informed the court her mother the 3 days later. A doctor confirmed that she had indeed been defied and had contracted unspecified infection. Marimingo was praised on his defense, and all he said was that he did not commit the alleged offense. He was in custody and unrepresented. The court delivered judgment and was convicted him. After mitigation, where he was maintained in social and was sentenced to life imprisonment and sent to Miti maximum prison. At Miti, he meets Fudijela, a fellow convict and a veteran. He narrates his case. Marimingo insists he was on way to Sierra on business on alleged date of the offense. He spent the night at Bowen Hotel and has found his receipt. He claims he was framed by his sister so that he disrelated from his parent vast estate. Anna could not have spoken to JAM. JAM has never spoken in her life. Mirigu is referred to you to appeal the judgment. You want to testify on the basis of the new evidence. So the 3 questions, the other question are there in Q&A. So we are going to look at the appeal, draft the appeal. Of course, because he's the chief magistrate, it is a petition of appeal. Remember what I told you last class? When the case is still going on, a ruling given by the magistrate will do a revision. But if the case has been concluded, you do a petition. That is the difference. So, the Republic of Kenya in the High Court of Kenya at Nairobi, Kiro appeal. Criminal appeal. Rubani Chief Magistrate Court, if you don't know where it is, so you can put Nairobi, that's okay. Marimungo appellant versus respondent. Petition, you quote section 50 of the Criminal Procedure Code. Marimingo, the above named appellant, appeals to the High Court against the decision of Chief Magistrate Honorable SM Kazi on 4 December 2018, where the appellant was charged with the offense of illicit contrary to section 20 of the Sexual Offences Act and sentenced to life imprisonment. The basis of appeal is on the following grounds. So, that the learned magistrate erred both in facts and law by failing to admit and qualify the alibi of the applicant. That the learned magistrate erred both in fact and law by failing to conduct a vivid examination of the victim because the child. That the learned magistrate erred in both in fact that the law by failing to consider the previous and ongoing conflict between the applicant and the victim's mother. Reasons whereof the applicant prays that this court that the reason whereof the apparent prays that this court, that the court, that this court, that this appeal, that the appeal, remove this, that the appeal be allowed, the sentence set aside, the conviction quashed. We said that, use the word in criminal cases, we said in another class, you said the conviction quashed and the sentence set aside. Are we together?
Yes, we're together.
Yeah, we have said that again. You don't say judgment. The conviction quashed and the sentence set aside. Dated at Nairobi, there's drone and fire to be served upon. So this is the area you need only need to perfect. That the appeal be allowed, the sentence set aside, and the conviction quashed. So that is apart from that, generally you have been able to do a petition of appeal, and we have dealt with it several times previous classes. So we go next now to the question that you are supposed to draft, which was question 4 July 2019. Question 4, July 2019. July 2019 is here. Of course, this one you drafted and sent me just some minutes ago before the class. So Kenya, I'm reading question 4, July 2019. Kenya is a signatory to the United Convention Against Terrorism. In fight against terrorism, innocent Kenya have been arrested and disappeared without trace. In the year 2018, Otek Ojok was arrested on suspicion of being involved in terrorism activities contrary to the Terrorism Act. His whereabouts were known for over 30 days. Efforts by family to trace his both at the local police station and mortuaries did not bear fruit. They did not know what to do. They therefore approach you having knowledge that you are students that are taking ATP at Kenya School of Law to advise them on the various issues touching on their circumstances. They concerned that the government has everything to do with the disappearance of their son. They argue that their son is suspect and he should be arraigned before a court of law to answer charges or be accorded a fair hearing. Preparing the necessary application citing relevant law that could make the state accountable for the prosecution of Tiede or Jerk. 10 marks. So this is a question that came in March 2023. Just the last paper that was done. So it's a very high unlikely to come. But nevertheless, we are going to look at it. When someone has disappeared, you are supposed to do a habeas corpus. Cannot be traced. You do a habeas corpus application. You used 545 to 533. Those are 28 minutes. Still out of time, but you are trying. A habeas corpus application can be done in 2 ways. You can do a miscellaneous criminal application via chamber summons or a petition. A petition you can do because now it's one of the fundamental rights and freedoms under the 2010 Constitution. But previously, you are supposed to do a chamber summons. And it can come as a theory question. So either way, you'll be right. So you chose to do a chamber summons in the High Court of Kenya at Nairobi, miscellaneous criminal. Here I've told you, you usually put criminal. Every time you are saying miscellaneous, you say criminal or civil. Are we together?
Yes, we are.
Yes, that change you make every time you are is because miscellaneous criminal, miscellaneous civil. Cause or application number. Then a joke is the applicant versus the respondent, the Inspector General of Police. So because you do certificate of urgency, because of the urgency of the person have been disappeared, Jerry, advocate of High Court practicing under the firm of conduct of this matter hereby certify the matter as urgent and the respondent being taken back into custody and continued detention of the applicant in custody in a breach of applicant constitutional rights. So chamber summon, you quote this article, you did well section, then this section 3.8, and then rules in the nature of habeas corpus. Head parties meet in the chambers on the day of 2019 at 9 on the forenoon as the counsel for the card be heard and the applicant. The application be certified as urgent, that the order for which of habeas corpus be issued directly at the respondent or his agent to have the body of Otieno Ojek be produced before the honorable court. 3, the order of the respondent or his agent to appear in person with the original warrant of arrest or detention to show cause why the applicant should not be released forthwith. Pending the hearing of the applicant, of hearing of this case, the applicant be admitted to bail or such at times as the court be deemed fit. That the court declares that the rights of the applicant should be been infringed, which application is based on the grounds that I told you, if you don't have grounds in your pleadings, of course, is legal grounds. You can go straight to the supporting affidavit, and also time. You can ignore the grounds. These grounds here because of time. Jane Ojori, the state of Karakoa, but here so many states as well, that I am not out of sound mind, brother of applicant here committed to show the affidavit that the applicant was arrested. So you have given the story. I think they don't think the supporting affidavit has a problem. So generally, habeas corpus you have been able to be able to do. So some of the grounds you can state there in your chamber summon, you can say that the arrested person has a right to be brought within 24 hours before a court of law. That is Article 41, 49. And also the article in the Constitution that talk about inhuman. Of course, you can talk about fair trial, inhuman, degrading treatment, against torture. Which article is that one? Freedom and security of person. That is Article 29. You can use it there. Even slavery, no, freedom and security of person, 29. Human dignity, 29. You cannot use all those. Right to life, 26. You can also put that there because even this person is not known there where he is. Are we together?
Yes, we are.
Yes. So IBAS Compass, you have you are generally you know how to do it, and it was tested last exam, so it's highly unlikely to come. CLE usually do not test a question directly the way it was tested in the last paper, unless it was a very difficult question. Then they twist a bit. So we go to the next. Our last drafting for the day. That is question 1, November 2019. And I'm going to read the question now. It's it's reflecting on the screen. Question 1, November 2019. Question 1A. Drafting. Harvey is a managing director of Kenya Subis Oversight Board. He appointed a tender committee under his mandate as accounting officer. Among those appointed was Kibos from his childhood friend to act as a chairman, and Ori Pope, his campus friend, who is a corporation secretary, as a member. Case SOB floated a tender for supply of soluble chemicals to be used in the laboratories countrywide. Several companies posted their bids. Ring Solution Limited was awarded the tender. The company is co-owned by Harvey and Olivia. The tender was awarded for the countrywide, so floated a tender for supply of soluble chemicals to be used as several companies posted their bids. Ring Solution Limited was awarded the tender. The company is co-owned by Harvey and Olivia. The tender was awarded for supply of 20 liters of soluble chemicals worth 40 million. Ms. Rose is the accountant at the corporation, and the instruction for Harvey made payment of 15 million to Ring Solution Limited even before any deliverables were made. So every time you are reading a question in an exam, whether it's criminal, civil, underline the most important facts. So if it is a criminal, if you are continuing to read the story, still a given time, the crime have not been committed. So from there, you underline the most important facts. It emerged that Ovia backdated the contract and signed the contract to allow early payments by accounts department. So that is one of these are criminal offense. Few months later, Ring Solutions supplied 10,000 liters of water card. The storekeeper received the 10 liters and signed the delivery note. Headman Jerry approved the additional payment of 25 million to Ring Solution Limited. The Ethics Anti-Corruption Commission received a tip from an anonymous caller. The CEO initially dispatched 5 investigators to KSOB to investigate the matter. Every welcomed the investigation to his boardroom, ordered meats and drinks from KFC. In addition, each investigation officer were given 500,000 as transport and disturbance allowance. Should investigators be given money by the company? There is something there. The investigation carried out the investigation and corporation recommend that the storekeeper Ruiz Jerry be charged with the offense of neglect of duty and abuse of other anti-corruption and economic crime act. Harvey, Mike Rose, and Olivia Pope were treated as prosecution witness. EACC forwarded the file to the DPP, who directed Louis Phil and Louis Leaf and Headman Jerry be charged with anti-corruption crimes offenses. The DPP also directed that this solution limited assets be frozen in addition of fraudulent acquisition of public property. They were all charged as directed in Milimani Anti-Corruption Code. Luis and Henry have requested you to represent them. They disclosed to you in confidence that they were on leave during the time of delivery, but ordered back to sign the documents. They also disclosed that they were not interviewed by ACC officials. That's another thing. They were also being suspended from office and now on half pay. They inform you that they were arrested, of course, being suspended from office and having on half pay. It is in the Public Officer Ethics Act. They inform you that they were arrested on Thursday night and they were arraigned in court on Monday. The right of arrested person to be arraigned within 24 hours. So, Marianne, do you see how you identify the issues?
Yes.
That's how in any exam, probate, civil, you underline the important issues, and you may even put them here in the side of the paper before even you look at what the question is asking you, because this is a long story, and you select the legal issues. So prepare the relevant application on behalf of your client, Louis Reef and Hardy Jeremy. So, of course, these people have approached you as you are the advocate. They have already been charged. And now the proceedings are continuing. So if you see this question like this, of course, they want to challenge the proceedings pending before the anti-corruption courts. And they are going to investigate the grounds. Even will start from investigation, what the police did, EACC, DPP, and now being charged at the EACC. So these are very common question. It comes a lot as theory, as drafting question. This is judicial review. Application. That was topic 12. We have dealt with habeas corpus extradition, inquest, application for inquest. Also acquaint yourself on inquest, theory question, and also how inquests are instituted by the DPP. You can also be told to draft. Look at that. I did not want to put so many questions on you. The new jurisprudence on children's court, minors with in conflict with the law under the Children Act 2022. You need to acquit yourself with that. Very, very important. This miscellaneous application freezing, it was asked as an application and I drafted it. It is there in year 2008 to 2019. So you look at it. Are we together?
Yes, we are.
All this area I usually tell you to look at it because we cannot look at everything in our class. So this question on judicial review can be done two ways. To challenge the police, the DPP, the EACC, they can be done two ways. They can be done through a judicial review application. And also it can be done through a petition, because now it's breach of fundamental rights and freedom. So if you have been told to the rights of fundamental rights have been infringed, the question is directing you to do a petition. If the question is telling you it's direct to seek leave, you do a judicial review. But if it is general, you can do either a judicial review or a petition. And they can also tell you the leave has already been given. So if you are drafting a judicial review application, you do a chamber summons, a statutory statement, and verifying affidavit. But if they have told you that the leave has already been given, also this apply in civil litigation, you now draft the notice of motion and supporting affidavit. Are we together? To that point?
Yes, we are. Although there's something when we learned it in class, we learned you can do. It depends, I think, on the question. You can do the petition, of course, and then you can do the usual judicial review. And we were told by Mr. Simiu that these days that in judicial review and after the what is it called? The notice of motion is now you are exempt from doing the supporting affidavit unless the court requires you to do it. You don't need to do it because they'll rely still on the statutory affidavit you had produced and the grounds you had done in both the chamber summons and the notice of motion. Okay. And then we also learned that if it's strictly a fair administrative action suit, like if you identify, it doesn't really touch on like other violations of law, it's just for administrative action, you can simply just do a notice of motion with a supporting affidavit under the Fair Administration Action Act, yes.
Okay. Sawa. And there are case law on this, eh? You need case law on all these areas, eh? You need case law on all these areas we have been talking about. We may not have time to deal with case law because next we are going to deal with probate, which is very, very important. But you see, the question usually says, answer must be supported by relevant case law and statutory provisions. Students usually use statutory provisions. When you are doing a theory question, you need to have at least one case for each need. So if it was, for example, all areas we have touched today, you need a case. Even this one for judicial review, this one, you also need to have a case law, which you are going to rely on in your theory question. Are we together?
Yes, we are.
So this question, you said you used 1 hour. 1 hour is 1 hour is a lot of time because it was 15 marks. I don't know how you are going to manage your time. Eh? A question of 15 marks, you use 1 hour.
I was interrupted on doing this question. So when I sat back, I don't know how much time I lost. So I just put the last, after I finished the notice of motion, that's the time I put in.
Okay, so Republic of Kenya in the High Court of Kenya at Nairobi Judicial Review Division. JR application number, Royce, Reef, Hardy, Jerry, second applicant, versus EACC, is the first respondent, anti-corruption court, Milimani anti-corruption court, you put here Milimani, and EPP as the third respondent. Certificate of agency. I, Nyamburi, an advocate of High Court who is conduct this video, speaker has certified that the matter is urgent, should be had expeditiously. When we arrested and in court and they took plea for criminal care, they deemed to have been unfair and breach of the applicant constitutional rights. Chamber summon ex parte, Section 8 of the Law Reform, and Section 711 of Administration Act and enabling the registration. Let all parties concerned attend the Honorable Judge in the chambers on the court on the day of 9th. Soon after that, the applicant be certified as urgent. The applicant by leave to apply for order, so try to remove the applicant cause the decision of the president to institute criminal proceeding against the applicant. Very, very important grounds. Orders. You are not able to put. You are supposed to. That you say that the state that the order be, given herein as prior stay of the criminal proceedings.
It's on.
Yeah. Sorry.
It's on the next page. I've written it. It's order number 4.
Yeah, you send me another. Yeah, can you send me that one? I don't have. Send me right now.
I sent it.
Send me again.
Okay,
send me again.
Let me resend.
Let me resend.
I've sent it. It was the second one with the no prosecute.
Okay. Sawa. This one I don't know. Sawa. Let me. I did not see. Okay, I did not download. So let me go to my WhatsApp here. Because we still have time, it's good we look at it substantively. This is a very, very important question. Usually comes a lot. It's a dear question, is a drafting question, both in civil and criminal. So, I'm opening my WhatsApp. But generally, I can be able to be using my phone. I can use my phone. So let me use my phone because it's taking time. I'm opening you have sent me. You can hear me, eh? Miriam?
Yes, I can.
So, so we have reached rate of parties that that an order of provision directed to the second from continue with criminal proceedings against the applicant. That this leave do operate a stay of criminal proceedings against the applicant. Then which application on the following ground? So we said here, the grounds must be legal grounds. That the investigation by EC was impartial as the investigator were bribed as such the applicants was never given a just and a fair opportunity to answer the allegations. That is okay. The applicant were held for more than 24 hours before being presented in court in violation of Article 49(1)(f). That is okay. That the decision to charge the applicant and the subscription of DPP is illegal and unfair. Which application in further supported and touched statutory statement and further grounds to be adduced in the hearing. So, statutory statement, you recite the parties, the applicant, Ruiz and Jerry. The address for purpose of this is first responder is a constitutional commission mandated to fight corruption. The second is a court special mandated to hear court cases. The third responder is a dependent office mandatory institute prosecuting criminal cases in Kenya. Relief sought. So you relief sought, you just put the one that you have given her there in the chamber summons. The grounds upon which the application is brought, you put also the grounds that you put there in the chamber summons. Verifying affidavit. Louis Reef within the public may swear that as the follows. I'm the adult of male in the another adult of male on sound mind and the applicant in the matter. I swear affidavit in support of the case. And the conversant with the facts matter, he read the concept of the chamber summons statement and verify. So you make it very short. That that is true to the hearing to the best of my knowledge. Swen, Nairobi, before me, commission of vote drawn by to be served to ACC, DPP, and then DPP, ESCC, DPP. That's okay. I can see here also you drafted continued under section 3. Not a prosecute. This is not a prosecute application. This was question 4C of November 2014, which we dealt with it in another class. I think the class, and of course, we said is a notice of motion. The Republic is the applicant, the respondent is the accused. Article 157.6 is the one, the article that the DPP usually discontinues, has power to discontinue proceeding against someone. 157.6. I think that is correct there. No, the correct section is to discontinue. To discontinue is 157.6 C. Okay, that's okay. Then you can quote 8. The director of public prosecution may not discontinue a prosecution without the permission of the court. So in fact, that is the most relevant. 157.8. 157.8, you can amend there in your pleading. Eh? Are we together, Marianne?
Yes, Mali.
So what does section 82 of the Criminal Procedure Code say? And 25 of ODPP Act. I'm not sure about those sections. Eh? So you can do this. Just quote Article 157.8 of the Constitution. What does 82 of the Criminal Procedure Code say? And
I can't remember.
I can't remember. So you can do this. Eh? You can cancel. Okay, let's look. Let's not cancel. So you can look at, you can open Criminal Procedure Code, and as I open the ODPP Act, because this is another,
okay.
This is another pleading I also want to be uploaded to the website, because is a document which is very rare to find. So I want the student to have the subscriber to the website now and in future to have the benefit of this drafting that you have done. So up you have said is Article 157.8, you amend there. In the one that you are going to send me. The Director of Public Prosecution may discontinue without the permission of the court. So he's seeking permission to discontinue the case.
Section 88 is also about permission to conduct prosecution. Oh, sorry, I'm supposed to look at 82. Sorry. 82 is the power of the DPP to enter null prosecution. Actually, the most relevant.
It's relevant. So section 25 also discontinuing. So the ODPP section 25 is also very relevant. It's talking about discontinuing of criminal proceedings. So you just change to put 157.8, not 6, eh? Sawa.
Yes, Mwalimu.
In the document that you are going to send me, November 2014. I think I can also open the November 2014. It is here. So, of course, there are a question that they have tested on this area, but not drafting was just tested one. So, okay. Process of dissemination. Prepare the following document. Notice motion. Assuming the leave was granted. Statement of facts. Question 4A. The process of criminal prosecution. 4C. We have been told criminal cases, okay, of 2013, that the applicant take notice that this honorable court will move on this day of 2014 in the form of the soon, so that the state council may be handled on the application of orders that the applicant, the state council, not the state, you amend, you say the prosecution council. Are we together?
Yes.
Be granted leave by the court to discontinue the prosecution against the accused person hearing who was arraigned before this court as per the offense of stealing by servant, contrary to section 281 of penal code, which application is based on the following grounds: that the accused prosecution which was an available have been found dead under mysterious circumstances on 11 2014, and the prosecutor had to found a replacement witness. That the instability in the case occasioned by frequent is occasioned by Al-Shabaab delay the presentation of the prosecution witnesses. That the police are required to carry out investigation in the accused complicity in the death of the accused, which application is further grounded upon the grounds be adduced and hearing hereof. So, of course, you did the supporting affidavit, and you have given the story, which is there, drawn and filed by Director of Public Prosecution. You can add there below to be served upon this person. Okay, you can leave it as the way it is, TPP, filed by. So you can amend those two things here, Article 157.8, and what else have we said? Prosecution Council. Sawa?
Yes, Mwalimu. You want me to send it to you separately?
You send it separately. I'm going to put it there in the website.
Okay, Mwalimu.
And the other one I've seen you have sent me.
Yes.
You have sent me. I'm going to put it in the website. Yes, I'm going to put it in the website. I'm also going to put your name. You have said that this one, do the amendments. Do the knowledge prosecute alone, and the two amendments. Then send me. I'm going to put it in the website.
Okay.
That's the people I know that there are people who are serious. And we have come to the end of criminal litigation drafting. This is the only subject we have derived with the substantive drafting of criminal litigation. Those two things that I've said there by Marianne on extradition and on the knowledge prosecute application, I'm going to state in the Q&A year 2008 to 2019. And the documents, I'm going to upload them on the website under Notes Area Criminal before the exams. So if you are revising on criminal litigation, please look at the documents and the others which I've stated there in the Q&A. They are very, very important.